All right, we're going to start on chapter 3 this time. This is probably one of the longer chapters in your book, and it's a very important chapter. It talks about the ethical and legal issues in nursing, something you're going to need to be familiar with as you embark on a career in the nursing profession. Again, I encourage you to follow along in your book. There are some really good boxes, tables, guides, and literature reviews related to this chapter. A lot of court cases are discussed, and that'll really help you in learning these concepts and helping you along the way. As always, I'll let you guys look at your learning outcomes. So, professional nursing practice is guided by Nurse Practice Acts. Every state has their own Nurse Practice Acts. Everything we can and cannot do is governed by our Nurse Practice Acts. They hold the weight of law. In Ohio, the OBN makes the rules we have to follow if you're residing in the state of Ohio. They say how often you have to renew your license, how much that license will cost. FYI, in the state of Kentucky, you have to renew your license every year. In the state of Ohio, it's every other year. They govern LPNs, RNs, advanced practice RNs, and CNAs. They also define unprofessional conduct. If you by chance are getting a license in one of the nurse license compact states, I'm not sure how many we're up to. It's not all 50 states, but the states around us here in Ohio are part of that compact. In nurse compact states, you are governed by your state of residence, i.e. where you are licensed, but you also must follow the Nurse Practice Acts of the state you work in. So if you're working in a state other than your home state, you must know both. It's real important. As far as licensure and stuff like that, you're going to follow your home state. But there might be little inconsistencies between two Nurse Practice Acts, so it's going to be really important that you know both of them. Now, negligence and malpractice. This is something, legal words that you need to be familiar with. Negligence, as defined by Black's Law Dictionary, is the failure to exercise the standard of care that a reasonably prudent person would have exercised in a similar situation. Any conduct that falls below the legal standard established to protect others against unreasonable risk of harm. So that involves your negligence, not doing what a reasonable and prudent person would do. In our case, it's what a reasonable and prudent nurse would or would not do. Malpractice is a civil action for damages that are generally derived from professional misconduct or professional negligence. Malpractice concerns professional actions, and it's the failure of a person with professional education and skills to act in a reasonable and prudent manner. So this is really important that you understand these. While negligence equates to carelessness, malpractice or professional negligence concerns professional actions. Both concern actions taken as well as actions omitted, and both are non-intentional. Another word you might heard this be called is an unintentional tort, T-O-R-T. That's an action. There are 4 elements of malpractice: the duty, the breach of that duty, the causation that that breach of duty caused something, and that the person has damages. Talk about that in a minute. The duty. The nature of duty is the legal obligation nurses have to their patients. These legal obligations are known as the duty of reasonable care. A nurse's conduct must be measured by that of other nurses in the same or similar locality or under similar circumstances, including the same educational level. So an expert nurse could possibly be held to a higher standard than a new grad. That doesn't mean you can do whatever you want, but just know that there is that that leveler, if you will, when it comes to actions and omitted actions. The breach of duty. Breach of duty is synonymous with failing to uphold the standard of care owed to the patient. Generally shown in court through the testimony of expert witnesses. As far as leadership, nurse managers are directly responsible for ensuring that standards of care, as well as written in hospital policy and procedure manuals, are current and that all nursing staff follow these standards. Should a standard of care be revised or changed, nurse managers must ensure that all staff members who are expected to implement this altered standard are apprised of the revised standard. That's why when a new standard or policy comes up, you might have to sign a paper saying, yes, I have reviewed this policy. That's why in all of your orientation, it's the expectation that you are being educated on what the standards are and that you know them. We talk about expert witnesses. They have to take into account the experience level of the nurse. So like I said, your experience. And these experts are most often other nurses. The injured party will often attempt to show that the acceptable standard of care is at a much higher level than that shown by the defendant, hospital, or staff. So reasonable standard of care, acceptable standard of care, not the deluxe. The third element of the medical malpractice such suit is causation. In this situation, the nurse's actions or lack of actions directly cause the patient harm. A direct relationship must exist between the failure to meet the standard and the patient's injury. Merely breaching a standard of care is insufficient to show medical malpractice. A direct cause and effect factor must be present. For example, a nurse failed to give an antibiotic to a patient and then the patient dies of heart failure. There's no cause and effect to that. A nurse may even fail to give a cardiac drug, but there still may be no cause and effect. There may be, but there may be not. Damages. And then the patient must be able to prove injury so that damages may be assessed. Purpose of the damages is to compensate the injured party for the harm that was done. Immediate and future medical costs can be assessed. So if you were involved in a medical lawsuit that resulted in a baby with paralysis or something like that lived, the hospital might be on the hook for years and years of care for that patient. That's why the sums are so great. Damages may include economic, compensatory damages, sometimes called actual damages, and non-economic damages such as loss of enjoyment of life, pain, suffering, or loss of companionship. Liability. Personal liability, individual responsibility, and accountability for actions and omissions. Vicarious liability, so that's you. Vicarious liability is the employer's accountability for negligence of employees. A doctorate of respondent superior, which means let the master answer, makes employees accountable for the negligence of their employees. The rationale underlying this doctrine is that the employee would not have been able to cause the wrongdoing unless hired by the employer, and the injured party would be allowed to suffer double wrong if the employee wasn't able to pay damages for wrongdoings. Nurses don't have the money, but hospitals do. That's where this vicarious liability came about. However, that doesn't mean that the hospital can then go back and try to sue you for part of that, the damages that were awarded. And then corporate liability, institution responsibility and accountability for maintaining an environment that ensures quality healthcare delivery for consumers. So this means that managers can be held liable, potentially suing the direct care nurse's manager if the manager knowingly allowed substandard and unsafe care to be given to a patient. Okay. Again, though, the institution has the right under indemnification, which is what this is called, to countersue a nurse for damages paid to an injured patient. The principle of indemnification is applicable when the employer is held liable based solely on the actions of the staff member's negligence, and the employer has to pay monetary damages because of the employee's negligent actions. So follow your policies, do what you're told. Preventing malpractice lawsuits. As a manager, you should ensure that employees meet or exceed the standards. Review standards periodically so that standards can be revised. Review policies regularly. Review randomly selected patient records for evidence that standards are being met. And then perform scheduled evaluations for staff. The other thing is, research consistently supports the idea that when nurses and healthcare institutions foster positive relationships, communicate effectively, and display compassion, families are significantly less likely to file lawsuits, even in the event of medical errors. Lawsuits are often driven more by feelings of abandonment, disrespect, or poor communication than by the mistake itself. So having a good relationship with your patient or family can possibly avoid a lawsuit. Causes of medical malpractice for nurse managers. Assignment, delegation, supervision, duty to orient, educate, and evaluate, failure to warn, staffing issues, accreditation, mandatory overtime, floating, temporary staff, and protective and reporting laws. We're going to go into those for a minute. So, duty to orient, educate, and evaluate. Nurse managers have a duty to ensure that staff members under their supervision are practicing in a safe, competent manner. And this starts with proper orientation. You might think your orientations are boring. You already know this stuff. But if an employer can't show that they went over something or educated you about something and that you acknowledge that you've received that education and understand, they can be found liable. After you've been educated on something, you're responsible for knowing this stuff you are educated on. So if you have questions, you need to ask questions. Failure to warn. If a person is fired for incompetence, an institution has a duty to warn other institutions of this incompetence when applicable. So your incompetence goes in your file, And if that institution that fired you is called for a reference, that institution is duty bound to inform the inquiring institution of why you were fired when it involves incompetence. And it's made in good faith between persons and entities with a need to know. Staffing issues. 3 areas to consider. Maintaining adequate numbers of staff, floating staff from unit to unit, or using temporary staff to augment current staff numbers. So this includes maintaining adequate numbers of staff members in a time of advancing patient acuity and limited resources. Managers who receive staff who are floated to their unit have a duty to make sure that that staff that is floated to that unit has the proper education in order to function as a nurse on that unit. If they don't, they might be asked to answer the phones or something like that. Same with the use of temporary staff. It's the nurse manager's responsibility to make sure that temporary staff has been educated on the workings of the unit and all practices and policies that deal with them. Accreditation. Organizations must make sure their employees are meeting the standards of accreditation. Excuse me, that grunting noise was my foster dog, who was probably injured in her throat during one of her times. So, sorry. Okay, mandatory overtime prohibited by several states. Protect employees from disciplinary action or retribution for refusing to work overtime. Establish monetary penalties for employers failing to adhere to the law. They can't legally make you stay. You will pass off your assignment to somebody, and they can't make you legally stay. This is talking about that floating staff to alternate units. We must make sure that units are adequately staffed. But as we do that, we have to look at staff expertise, patient care delivery systems, patient care requirements before deciding which staff to float. So if you're an ICU nurse, it would be reasonable that you would be floated down to a medical surgical floor. If you were a nurse on a medical surgical floor, it wouldn't be reasonable or prudent to have you float to the ICU. Cross-train staff during times of adequate staffing. So that's a suggestion that managers often heed when people do get floated to their unit. Managers and healthcare organizations can be held liable for poor staffing in the event of a patient injury. Poor staffing should be reported on an incident report. Because if anything ever came out about that day where somebody was injured, you want to communicate with your risk management team that poor staffing could have contributed to the problem. Again, temporary staff. Patients can infer that agency staff are working directly for the institution. Thus, it's imperative that the agency or temporary nurse can deliver safe and competent nursing care. Agency staff must adhere to the hospital policies and meet the standards established for that organization. Protective and reporting laws. This includes the mandatory reporting of incompetent practitioners. You have a duty to report incompetent and impaired practitioners, and this can include fellow nurses. Failure to report can result in disciplinary actions by the board on the person who fails to report, typically being nurse managers. If you have an experience with an incompetent, impaired coworker, you should be reporting that to your manager. Informed consent. An explanation of the treatment of procedure to be performed and the expected results of the treatment of the procedure must be communicated by that person who will be doing the procedure. Nurses often ask about issues concerning informed consent that involve the actual signing of the informed consent document, not the teaching and information that make up the informed consent. You, as a witness, are attesting only to the voluntary nature of the patient's signature. No duty on the part of the nurse to insist that the patient repeat what has been said or what the patient remembers is present. If a patient asks questions that alert the nurse to the inadequacy of true comprehension on the patient's part or expresses uncertainty while signing the document, the nurse has an obligation to inform the primary healthcare provider and appropriate persons that informed consent has not been obtained. So you're just attesting to the person signed it, not to their understanding of what's in the informed consent. However, if they start asking you questions, you must direct that back to the provider. Research involves another type of informed consent elements, and these are listed in your book. The degree to which individuals have the capacity to obtain, process, and understand basic health information, including services needed to make appropriate healthcare decisions, must be taken into account. Functional health literacy relates to a person's ability to act on the basis of health information received. Within the medical context, the law recognizes the patient's right to protection against appropriation of a patient's name or picture for the institution's sole advantage, intrusion by the institution on a patient's seclusion or affairs, publication of facts that place the patient in a false light, and public disclosure of private facts about the patient by the hospital staff. Confidentiality is the right to privacy of a healthcare record. Institutions can reduce potential liability in this area by allowing access to patient data, either written or orally, only to those with a need to know. Persons with a need to know include physicians and nurses caring for the patient, technicians, unit clerks, therapists, social service workers, and patient advocate. This need also usually extends to house staff and consultants. Your policies and your procedures. These documents set standards for care for the institution and direct practice. They must be clearly stated, well delineated, and based on current practice. Must be reviewed periodically, even if no changes are expected. Nurse managers should review the policies and procedures frequently for compliance and timeliness, and make sure those under them are up to date on all policies. If policies are absent or outdated, the nurse manager must request the appropriate person or committee to either initiate or update the policy. Employment laws. I'm not going to go into all of these employment laws. You guys can read about those if you want. I do want to talk about the the Family and Medical Leave Act specifically. That's the one a lot of us have interaction with. Every organization has their own process on how to follow the FMLA rules and laws. This includes how and if this leave will be paid or unpaid, or a combination of employees' earned time off and other possible compensation. There are specific reasons why somebody can be deemed FMLA. FMLA does not have to be taken all at one time. And it is protection for the worker so that they don't lose their job in the event that they do have to care for a spouse or parent with serious health problems. Employment at will and wrongful discharge. This is a rough one. Employers can hire who they want, and that potential employee can accept or turn down a job if offered. But employers just can't fire you in certain situations. Some examples include discharging or firing an employee for serving on a jury, because that's their civic responsibility. Reporting employers' illegal actions, better known as whistleblowing, or the disclosure of information regarding misconduct within a workplace that either is illegal or endangers the welfare of others. They also can't fire you for filing a workman's compensation claim. Several recent court cases attest to the number of terminations in healthcare settings that serve as retaliation for the employer, more commonly known as whistleblowing cases. The healthcare provider in these cases is terminated for one of three distinct reasons: speaking out against unsafe practices, reporting violations of federal laws, or filing lawsuits against employers. Essentially, whistleblower laws state that no employer can discharge, threaten, or discriminate against an employee regarding compensation, terms, conditions, location, or privileges of employment because the employee, in good faith, reported or caused to be reported verbally or in writing what the employee had a reasonable cause to believe was a violation of a state or federal law or rule or regulation. Most whistleblowers are internal. That is, they report misconduct to a fellow employee or supervisor within the agency. External whistleblowers are those who report misconduct to those outside the agency. And there might be situations where you have to do that. So this is kind of morphing into professional nursing practice ethics. When I was in school back in the dark ages, we actually had a class that was called Law and Ethics, and it was required that we take it. Now it's part of your leadership course, but we were required to take this. So this is talking about why individuals within a society do things or concern the individual within society, and why of actions as opposed to what was done or not done. Often encountered in conjunction with legal concerns. So the Terri Schiavo case, you guys might not remember the Terri Schiavo case. It was a highly publicized legal and ethical battle between 1998 and 2005 in Florida over removing a feeding tube from a woman in a persistent vegetative state, sparking national debate on end-of-life care, patients' rights, and government intervention. Her husband argued that she wanted to die, while her parents fought to keep her alive, leading to numerous court rulings and legislative efforts, culminating in the tube's removal in May 2005, followed by her death 13 days later of brain atrophy. The case highlighted profound ethical questions about autonomy, end-of-life decisions, advance directives, and the government's role in private medical matters, sparking ongoing debates. When we think about ethical principles, these are no different from anybody or any profession. Autonomy, beneficence, confidentiality, fidelity, justice, non-malfeasance, paternalism, respect, and veracity. The ANA publishes a book called Code of Ethics for Nurses with interpretive statements to help nurses understand these ethical principles. And your book has some really good examples of these that you might see. Professional codes of ethics, formal statements that articulate values, beliefs of a given profession. Again, that ANA book that is called Code of Ethics with Interpretive Statements is what our guide is. We talk about ethical decision-making framework. It's the use of orderly, systematic, and objective method. So this is the one where you have a ventilator and you have a woman of 3 or a person who's in prison and then a priest. Who gets the ventilator? And I think, during COVID, they might have been making some of these decisions. But hopefully now there are such orderly, systematic, and objective methods. There's a really good a good movie, and it's called The God Committee, and it talks about how, it's about an hour-long movie. It talks about an ethics committee, and they are given there's a heart available, and 3 people need this heart. And it shows the process that they go through in order to decide who gets that heart. And you might have a thought in the beginning, and that might not be what is decided in the end. Or you might have no idea in the beginning, and then towards the end, you make your decision, and it's different from the committee. It's a really, really good movie. The God Committee. I'm not sure where you can watch it now, but it's really good. Moral distress occurs when faced with situations in which 2 ethical principles compete. Again, I'm sorry if you hear snoring. The ANA has published Exploring Moral Resilience Towards a Culture of Ethical Practice. So they understand that this sometimes can be an issue. It was probably a big issue during the times of COVID. There's been a lot of studies done on those in the military who experience a lot of moral distress. A friend of mine actually got her PhD looking at this very thing. Again, ethics committees provide some long and short-term assistance, providing that structure and guidelines for potential problems, serving as open forums for discussion, functioning as patient advocates by placing the patient at the core of the committee discussions. Again, that movie, The God Committee, is really good. So, in wrapping up here, you must read and comply with provisions of the State Nurse Practice Acts. You must apply legal concepts in all healthcare settings. Understand and abide by state and federal employment laws. Implement the provisions of the Code of Ethics. If legal and ethical issues are contradictory, legal aspects take precedence. All right.